Good morning, good afternoon, and good evening. Thank you so much for joining us. I am Professor Dr. Luis Maria Palma, President of the International Association for Court Administration, IACA. Today, we are developing the third session of the online conference program jointly organized by IACA with the State Judicial Administration of Ukraine, the EU Project Pravo-Justice, USAID Justice for All Activity, and All-Ukrainian Association of Court Employees. This conference is dedicated to establishing the system of support to vulnerable groups of court users and victims of war crimes. The topics to be covered by the distinguished experts who honor us with their participation as speakers are specifics of working with witnesses and victims of war crimes as a particularly sensitive group of court participants, best practices for arranging premises in the court for working with different categories of vulnerable persons, access to justice for vulnerable groups of court users, court volunteer service. Ms. Yevenila Bondarenko, national expert of the EU Project Pravo-Justice project, and I will serve as the moderators. Now, I'll briefly describe the rules for the session. The online conference will be recorded. We'll introduce each speaker before the presentation. After all the presentations, there will be approximately 15 minutes for questions and answers. We'd appreciate if you could send us your questions using the chat box and identify the speaker to which they are addressed. We kindly request you to mute your microphones. Please, Mr. Oleksiy Sarnikov, Head of the State Judicial Administration of Ukraine. Thank you.
Доброго дня, дякую вам.
Hello, thank you so much. Dear colleagues, dear participants of the conference, the topic is as relevant as ever, given the conditions in which we live today. Unfortunately, the war that's ongoing in Ukraine only decreases the number of vulnerable court users. That's why, apart from war crime victims, almost all population of the country is suffering from psychological and emotional stress. And the number of such target groups as in particular servicemen and the members of their families, and we see that a special care and attention should be given to the victims from war crimes. As a rule, there is information support that is necessary for the participants in order to make sure that they don't have that much anxiety while they're on court premises. It's very important to ensure this respective logistics and respective measures to put in place in courts about, in particular, about hardware and equipment. People must feel that they are protected and creating volunteering services is one of the special informational and psychological support for the members of the trial. That is why, for the State Judicial Administration of Ukraine, it's very important to introduce the initiatives for the vulnerable court users in order to maximize the client-orientedness of Ukrainian courts. Together, jointly by courts, we take measures to make justice more accessible in some appeal courts and in some general courts, given technical and architectural capacities. Court staff on their own have introduced the children's room, both for the waiting area as the court users and for interviewing them. We are thankful to our international partners for active and beneficial support they have been providing in this regard. Thus, in the last 3 years, together with the EU Project Pravo-Justice, we have implemented many initiatives on introducing special services in Ukrainian courts that are aimed at vulnerable court users. In particular, we have held 3 special training courses on arranging services for vulnerable court users.
навчання та отримали відповідні сертифікати.
And that's where there were over 100 participants who participated in the trainings and that got their certificates. In particular, it is the representatives of judicial sector institutions and NGOs. We also introduced volunteering services in courts. Today, with the project support, there are respective court services that unite 300 volunteers. Moreover, the model court handbook was developed, drafted in order to take into account all the best practices and recommendations on how it is necessary to ensure the categories where people can wait, how to organize courtrooms, how to maximize the maximum security courtrooms, and provide for a space where clients can communicate with advocates. Also, we have there are recommendations on children's rooms. There is also practical help in such children's rooms, since there were many conferences held that covered many participants. All these instruments, without saying, have positive impact on court users and visitors, but given the new challenges brought about by the war, one of the priorities of the State Judicial Administration of Ukraine is to improve judicial administration in the course of considering war crime cases. Thanks to our international partners, USAID Justice for All and the EU Project Pravo-Justice,
Приділяли саме питанню підтримки жертв та свідків воєнних злочинів,
for
кримінальних
providing special support to vulnerable victims and court users in court proceedings and administering cases on war crimes provided by USAID project has helped us to identify the priorities in this regard. It goes without saying that on the path towards implementing the support of vulnerable court users, there are a number of issues and challenges that need to be addressed. There isn't everywhere spaces and waiting areas for victims, and separate rooms for interviewing persons and children's rooms. Given that our current construction norms do not provide for children's rooms in courts, it's also a challenge. And over the last year, the Ministry of Territorial Units are discussing how to adapt these buildings to new standards. Also, it's very important to ensure information confidentiality that is related to protecting witnesses.
забезпечення інтернетом, провадженням інших інформаційних технологій.
Holding video conferences and ensuring uses of other respective technologies in order to interview those persons. We're looking for solutions how to make it work. It's very important for the State Judicial Administration that it has access to information on supporting vulnerable court users and on practical ways of implementing them. It's also important for us to look into the requirements of valid legislation in other countries, in order, for example, to look how they arranged special courtrooms for consideration of the cases, with the participation of vulnerable court users, victims, and witnesses of other crimes. I want to thank our international partners for their support that is very much important and relevant right now at such tough times like this. Together, we will take care of all the challenges. May you have good mood, productive exchanges, and interesting information. Thank you so much.
Thank you so much, Mr. Sannikov. Please, Mr. Volodymyr Chavan, key national expert on judicial reform of the EU Project Pravo-Justice.
Дякую, доктор Пальма. Шановні
Thank you, Dr. Palma. It's indeed an honor to be here on behalf of EU Project Pravo-Justice and welcome you here. And thank you for being at our event. It's a pleasure to see that there are so many participants here. Now I see already over 223 participants.
що для нас є особливо приємним.
It shows that this topic is very important and interesting, and that a lot of people are concerned how we can support vulnerable court users, in particular war crime victims and witnesses. That is one of the very important strands of work and work streams within the model court workflow of the Pravo-Justice project. When emphasizing the importance of this topic, it goes without saying the judiciary in any country must take into account and provide proper response to the needs that arise when providing services to different court users, vulnerable in particular. Moreover, due treatment of victims and witnesses is the basis for the rule of law, because without internal conviction about justice system, it's impossible to secure proper operations thereof. And what Alexei Salnikov has drawn attention to, it's important for courts to have respective premises and provide specialized services for the vulnerable court users, in particular war crime victims and other persons who, under specific circumstances, will be considered as vulnerable. May all of us have productive work here. I'm sure that not only our Ukrainian partners can find more about best practices, but our foreign colleagues also here, Ukrainian best experience they can implement in their respective countries. Thank you.
Thank you very much, Mr. Chavan. Please, Ms. Uliana Pashina, legal advisor of the USAID Justice for All activity.
Thank you, Dr. Palma. Доброго дня всім. Передаю вітання.
Hello, everyone. All the best wishes to you from USAID Justice for All, from Mr. David Vaughan. He is right now involved in a different event. That's why he couldn't join us today. But as Volodymyr said, it's a pleasure that we have here so many people. That shows how relevant this topic is. We are happy to support the State Judicial Administration and the International Association of Court Administrators in holding this important conference dedicated to establishing support services for vulnerable court users and the victims of war crimes. We have drawn attention to this topic in our research mentioned by Alexei Salnikov. Its need assessment of judicial administration in war crimes cases. We presented this research last year, and today, together with us, we have Evelyn Anoya, who was the co-author of this report, and she dedicated a lot of information and attention to this, and she provided extensive advisory support in this regard. We're also happy to have here Katerina Shinevich from the URFEM, the Association of Women Lawyers of Ukraine. It has just finished the research conducted with our support that is called Gender Dimension of the War, and it looks into gender analysis of the patterns in deporting, for example, civil population of Ukraine, in particular Ukrainian children, the issues of destructing civil infrastructure and buildings and reparations. And a lot of attention was given here to sexual violence related to war, and the matter of introducing gender-sensitive approach in working with such conflict-related sexual violence crimes. It also should be mentioned that we provide active support to the initiatives of the efforts taken to bring war criminals and perpetrators to responsibility and ensuring access to justice for victims. We work with the National School of Judges of Ukraine for training of judges who consider war crime cases. We are ready to further support the State Judicial Administration in investigating and adjudicating war crime cases, and we do everything possible in order to ensure access to justice for those who suffered because of war crimes. We also support local NGOs and civil organizations who work with vulnerable persons, and in particular with victims of war crimes, and they provide legal and psychological support to these categories of people. I again thank our partners, the Judicial Administration of Ukraine, International Association of Court Administrators, EU Project Pravo-Justice for cooperating in this regard, and may we have good event. Thank you so much.
Thank you so much, Ms. Pashina. Now we'll start with the topic, specifics of working with witnesses and victims of war crimes as a particularly sensitive group of court participants. Please, Ms. Evelina Neuer, adjunct professor at DePaul College of Law, international justice consultant with TAG International, and former chief of judicial services at the Special Tribunal for Lebanon.
Can you hear me now? Great. Thank you very much, Dr. Palma, and greetings to all of you. I'm honored to be here today and to share some information that I hope will be helpful on some level to you in the way in which you approach your cases nationally. So the way I was hoping to start this presentation is by starting up front with the good practices. Usually I leave those for the end, but I think it's important to start with what is needed in order to be able to move in the right direction. Obviously, clear legal framework is important. Secondly, a clear internal structure is also important. And I'll say more about what we've learned at the international tribunals in a few minutes. In order to ensure consistency across different courts and different sections and also parties, it's important that also policies are written and procedures are written clearly, succinctly, in a very, not too legalese, but in a clear manner so that all those participating in proceedings and also those dealing with vulnerable victims, witnesses, or those with dual status know what the court's policies and procedures are. And also the requirements for vulnerability assessment should also be clear and communicated. And there is a need to have a protocol also for consistency. The confidentiality principle is at the center of protection. So the way in which you design the legal framework, your internal structures is all moving in that direction to make sure that those who are vulnerable and those who may require protections, that the confidentiality provision is very clear. And that also protects them mentally, physically. So witness protection is a part of states' obligations to uphold human rights. And I'll say a little bit about that in a minute. Victims do need to be afforded access to effective remedies. And also effective remedies do include protection and support for victims and witnesses to ensure that they can safely participate in testifying or following or participating directly in proceedings and to tell their story. But they need to be able to trust the process and trust those with whom they will be communicating and engaging with from the beginning to the end. We start with the human rights framework because even at the international tribunals, the inspiration is to ensure that we are adhering to the highest level of human rights obligations. So we are looking at the obligation to ensure that individuals do have effective access to or access to an effective remedy. This is something that is across different systems as well, also within the regional human rights mechanisms. The EU itself has also implemented this in their own directives, but for the purpose of what I'm saying today, I want to just highlight the UN specific, since the tribunals often are created through the UN mechanisms. The Human Rights Committee has come forward and given us also guidance, and they have affirmed that protection requirements do emanate from states' obligations to respect and ensure rights, and then they recommend effective witness protection mechanisms to be established as a part of the obligations to protect those individuals' rights. I've highlighted the declaration. There's also an EU declaration from 2012, but the UN declaration being adopted by the General Assembly says taking measures to minimize inconveniences to victims, protect their privacy when necessary, and ensure their safety as well as that of their families, witnesses on their behalf from intimidation and retaliation. So when you look at the way in which the witness protection system is designed and what we have relied on through the years in managing war crimes, we look at witness assistance and we look at witness protection. So for the purpose of witness assistance, also dual status, so victims who are also witnesses, we're looking at financial support, we're looking at medical support, material support, psychological support, social support, and legal support. And I don't want to lose sight of legal support. That's just as important when we're dealing with victims who do have particular concerns. And this assistance is provided throughout the legal process. It doesn't necessarily start and finish at a moment during the trial. It begins before proceedings and continues to the end, and I'll say more about that. With respect to witness protection, we're focusing on protecting the safety of victims and witnesses and others closely associated. And I'm sure my colleagues will repeat this theme also throughout our discussion today. We're looking at physical violence, threats of violence, intimidation, retaliation, and other harassing conduct. It's not always clear cut. So assessments and clearly listening and hearing from the vulnerable individual is important to be able to understand the threat. And as I just indicated, the protection is provided at the moment of contact, so before, during, and after testimony. So the basic principles, to run through them quickly, your assistance is triggered from the first interaction that may create the risk. So when you look at the International Criminal Court, the protection model that is used is not only for individuals who take the stand, it's also someone who may be at risk by the mere contact with the court. So it is a bit more, and the Special Tribunal for Lebanon also used the same principles. So it's that interaction, that contact, that first contact that may create a risk, and it continues until that risk is removed. And witnesses, for the purposes of international cases, can be called by the prosecutor, can be called by the defense, legal representative victims, but also the judges themselves. And so in our system, the registry, which is the neutral entity supporting the court, supports all those who are calling witnesses or who may have interactions with potential victims and witnesses. Protective measures should be in place as early as possible throughout each stage of the proceedings and up until there is no risk. All actors in the process bear responsibility regarding that protection. And the protection encompasses, in the same way, physical safety, but also the psychological well-being and the dignity and private life of the person. We have worked very hard through the years in building also the psychosocial support that's given to those individuals. The need for witness assistance and protection arises, but at the beginning, as I indicated, and includes also post-sentence or acquittal. At the international tribunals, there would be, and I can't stress this enough, and this also comes through the report we prepared, there would be a substantial gap without a functioning witness assistance or protection program led by a neutral entity that supports all those who are calling victims and witnesses or who are engaging with them for the purpose of the proceedings. So when we look at protection, we're looking at limiting information sharing, we're looking at protective measures, we're also looking at security arrangements, we're looking at counseling, and other appropriate assistance. Just run through this. The protective and special measures provide the means to protect witnesses and victims' right to safety, physical, psychological well-being, dignity, and private life. And during the judicial proceedings, a chamber, the judge or a chamber leads and controls the proceedings by making sure that the necessary protective measures are granted or varied if there's a determination that circumstances have changed, and the circumstances can change in different ways. So an individual can start as being protected and will no longer require protection, or vice versa. So someone can be testifying openly, but then determine that they are now at risk and need assistance. So vulnerability of a witness can be determined by different factors. We're looking, and the ICC does provide guidance on this. I've just summarized it here for the purpose of our discussion. It's related to the person, and you're looking at age, children or elderly, personality, disability, mental illness, psychosocial problems such as trauma-related problems, and or lack of social support. You're also looking at the nature of the crime, in particular victims of sexual or gender-based violence, children that are victims of violence, and victims of torture or other crimes involving excessive violence. You're looking at circumstances such as significantly increased stress or anxiety due to relocation, resettlement, or fear of retaliation. The issue of retaliation comes up quite a lot, and adaptation to difficulties related to also cultural differences or other factors. Measures will be put in place to prevent further psychological harm that may result from appearing before the court. And in advance of judicial proceedings, a neutral court staff, a member of our registry staff, familiarizes individuals with the court proceedings. What you find is that oftentimes individuals have never entered a courtroom, they know nothing about legal process, but they want their story to be heard, they want to tell their story, but there's a lot of fear around it. Also fear of seeing and being in front of an accused who they may have directly been affected by. So it's important that they fully understand from the minute they participate in court process what it entails and what is included, and that communication is very important. So with regards to the actual judicial protective measures, and I'm sure you've seen this in other forums, you're looking at pseudonyms, you're looking at non-disclosure of the identity of a witness until it's absolutely necessary for adequate preparation of the defense. The defense rights are always a part of the equation. You're looking at image or voice altering devices, testifying possibly behind a screen or curtain, testifying by video link from an unknown location, or testifying in closed session. Closed session is rarely used because the principle of ensuring that proceedings are as much as possible in the public forum with different variations of protective measures is what's encouraged by the rules of procedure and evidence. So this is a pixelated image. You have, especially if you're intending to broadcast proceedings, the computerized tools are used to alter the voice and alter the image. Inside the courtroom, because this is the courtroom of the International Criminal Court, it's a massive building. I think your courtroom's a lot smaller, but you're always taking into consideration how the individual will feel in the courtroom. So you reduce, when necessary, the number of people in the courtroom, avoid naming people in the courtroom, also remove from the public record, we call it a redaction process. We remove information that potentially could disclose an identity of an individual from the transcript or from the audiovisual. And those are very clearly defined policies and procedures. We also, in extreme circumstances, we do allow a support person to be inside the courtroom with the individual to support them. And it's more of a hand-holding support to just let them know that they'll be okay. The psychologist is continuously monitoring the witness inside the courtroom during the judicial proceedings, and they also do, if there are additional vulnerability issues, they will also brief participants if necessary in terms of risks and concerns and how best to approach a vulnerable witness. The witness will receive a debriefing also after the testimony. The psychologist will also check the mental state of the individual, and if necessary, refer the matter for further assistance to normally a national expert, but that's only when it's necessary. And they'll be given also an opportunity to make contact with family. And this has a dual purpose. It's to also understand through the family how the testimony was received. So that together with the protection experts, they will do an assessment to determine whether there is a heightened risk now that they've testified to return to their place of residence. So they monitor the impact of the testimony. There's what we call a cooling down period, and that cooling down period also allows for an assessment to make sure that they're safe to return. So they don't return immediately. We often have them in a safe holding area to provide additional support. Should concerns about security occur, and often something may occur, especially if they've been moved out of a small village to testify, the staff experts will communicate this to the judge often or to the calling party. So and this is through the neutral entity, they will tell the individuals, the court, what is happening, and then advice will be provided from the protection experts on what measures to take. In serious circumstances, an assessment will be then conducted by the protection officer to determine if the person should participate then in a protection program. So we really follow the consequence or the impact of them giving testimony. Thank you very much. I'll leave it with this. I'm sorry I took some extra time. I think my colleague will now continue.
Thank you so much, Ms. Anoya, for this thorough presentation to share good practices, substantial and procedural protection measures, and achievements in this crucial area, considering witnesses, victims of war crimes, dignity, and human rights at the center of each and every effort. Please, Ms. Katerina Shunevich, head of the Analytical Center URFEM, Ukrainian Women Lawyers Association.
Усім доброго дня. Щиро дякую за можливість взяти участь в цьому заході.
Good afternoon, everybody. Thank you very much for having me here. I will probably take over from the previous speaker because my presentation will be kind of a follow-up to what the esteemed speaker Evelyn Anoya was presenting to the participants. First, I will develop on the specifics of working with victims of war crimes as a particularly sensitive group of court users. I will say now a few words about the organization I represent, namely the Analytical Center URFEM. Our center provides gender sensitive analysis of legislative and regulatory framework which is being developed by Ukrainian authorities. We also organize discussions where we raise gender-related issues and problematics in various areas. Next slide, please. I would want to say to cover today, a victim survivor-centered approach, which should be applied to all victims and witnesses of violent crimes, and which should be based on such notions as respect, non-discrimination, safety, confidentiality, informed consent, and support and prevention. So in a nutshell, we are talking here about the implementation of gender-sensitive best practices on the ground and training stakeholders in case of the judicial system. We're talking about judges, court staff, and professionals which may involve in the operation of court. So proper training is necessary in order to actually ensure a victim survivor-centered approach, in order to avoid re-traumatization of vulnerable victims and witnesses, and in order to ensure high quality investigation and adjudication based on reliable evidence received from such witnesses. In order to ensure greater security and safety of vulnerable users, it may be recommended to hold closed court sessions as practical as if applicable at the trial stage, while also ensuring maximum security and privacy at the pre-trial stage when giving evidence. So these measures are extremely important in investigation and prosecution of war crimes, but especially when it comes to conflict-related sexual violence. And here we need to mention, alongside all the above mentioned, the principle of informed consent. So this is where we need to remember about the necessity to inform victims and survivors about what is going to happen to them, in order to make sure that they understand and realize each step they are expected to make on the path of investigation of such crimes. As it has been mentioned today, support and assistance need to be provided not only before and in the time of investigation and prosecution, but also after that, because many people face so-called consequences of violence, sometimes without even properly realizing that. So if we try to structure victim-centered approach, I would say that the first most important component would be informed consent, which we have already discussed today. The second component would involve privacy, which provides for the person's right to confidentiality and to not being exposed to certain things if a person is not willing to be exposed. The third component can be formulated as do not harm, which means that victims may refuse certain actions and activities if they feel unsafe. Avoidance of re-traumatization and further support are fourth and fifth principles and components we have been talking about. So the key ethical principle underlying the documentation of sexual violence is the commitment to do not harm. It means that if a vulnerable person feels not being able to participate in certain investigation activities or undergo questioning, it means that such a person should not be forced to do so, but should be properly assisted, for instance, by the psychologist. Next slide, please. Another important thing we should remember about is the autonomy of victims.
Розуміти, які дії очікують, і робити вибір щодо того, чи
Person
брати
has the right to understand what actions are to be taken, whether to take part or no. So then we have informed consent, that is understanding of what is going to happen and being able to choose what to do. And informed consent is a dynamic and not one-time situation. It means that once person agreed to take part in one procedural step, it doesn't mean that a person will do that every time. In particular, it's relevant when there are in respective interrogations or interviews and repeated questions, sometimes improper questions that re-traumatize the person. Next one, informed consent is a legal obligation, which means when it's necessary to accept it. Next one, information about witnesses and witnesses must be stored confidentially and only within the criminal proceeding, and dissemination of information must do no harm. Next step is the practices at the pretrial investigation stage and the trial stage. They must not stigmatize and victimize the person. That is, no person is guilty of what violence was done against you. And then the question, what did you do to prevent this? Or other similar questions do not help to be sensitive in that regard. Next one about recommendations and items of advice. It's important to monitor emotions, to be active listener and not to interrupt, that is, give a person a chance to say what she or he wants, to use inclusive language. Here in Ukrainian criminology, we try to say a person that jurors do have a respective understanding of a victim, and it's also important to ensure that the respective language is used for that. Then, as a conclusion, to work according to a victim-centered approach, to take into account all the necessary things, not to blame the victims, to treat all victims with dignity and respect independently of the experience that have had, and to recognize that the priority of the safety and dignity of the victims is of primary importance. It's all a set of intersectoral approach. Now let's have a look at our next slide, both about legal help and medical help and psychological help and social and economic support. All that is a comprehensive interdisciplinary approach that would help protect the persons. It all ensures respective avenues. That's also a matter in terms of legislation, of amending legislation. At this next slide, we have an overview of the research that we've been working on. Please pay attention to the fact that you can look it up in Ukrainian and in English. And here you can also look into gender aspects of war crimes and why it's important to be aiming your work at victims. Thank you so much, everyone, for being here and for listening to this intervention.
Thank you so much, Ms. Sinevich, for describing so profoundly the importance and complexities of the victim-centered approach development, the principle of relationship with the victim, and the key relevance of empathic communication and ethics in all these regards. The following subject is best practices for arranging premises in the court for working with different categories of vulnerable persons. Please, Ms. Sonia Prostrom, Chief of Party of the East-West Management Institute under USAID funded Judicial System Strengthening Activity, JSSA, in Uzbekistan, and also founding member of IACA.
Thank you, Luis Maria, and thank you, everyone. Good afternoon from Tashkent. It is really a pleasure to be in this company today. However, I also must say that I hoped actually that my experience with establishing the War Crimes Court in Serbia would not be needed for anyone anywhere in the world. And in that sense, I feel kind of strange today. I was one of the establishers of the Victims and Witnesses Support Unit within the War Crimes Court in Serbia, but I thought that no one would ever need that expertise. And in that sense, my emotions for participating in this conference today are very mixed. I am not a civil engineer. I am a former judge, a former criminal judge, and I was for a while a spokesperson of the War Crimes Court in Serbia, and hence my involvement with victims and witness protection, particularly related to the war crimes. I understand that my topic today is a bit broader than war crimes, victims and witnesses. But given your interest and the focus, I will actually mostly relate to those vulnerable groups that may appear before your courts in the near or not so near future. We have, although the war in former Yugoslavia ended almost 30 years ago, we still have active cases and we still need witnesses and victims protection. Next slide, please. What you will see in my presentation is just a collection of photographs showing different types of courtrooms and different types of premises where victims and witnesses can find themselves. Courts are still not structured to be friendly. Courts are structured to kind of cause fear to everyone that appears in the courtroom. And many of my colleagues would say that is how it should be. People should be afraid of the justice. However, certain categories that appear in the courtrooms, as you are all well aware, are really not fit for that environment, starting from children, regardless of whether they are witnesses or victims. Children really don't feel safe in this environment. So this before you is a classical US courtroom in one of the US state courts. Next slide, please. This is the courtroom in the country that I'm currently working in Uzbekistan. So you see the difference. I mean, the main difference between this and the previous photo is that this one has a video conferencing system, and all the courts in Uzbekistan, and there are more than 400 of them, are equipped with this system, so the not only remote participants in the court hearings, but also vulnerable ones can be heard via video conferencing. Next slide, please. This is the second largest courtroom in the world. This is Serbia War Crimes Court, Courtroom 1. And as you can see, it really reminds a lot to the ICC courtroom that Evelyn showed to us before. And we did actually take a lot of the experience, both from the ICC and International Criminal Tribunal for former Yugoslavia, when setting up our own war crimes court. But this is a huge, huge courtroom. And on your on your left-hand side are actually these are the booths for the prosecutors, but also for the representatives of the victims. And behind them, behind the glass, usually are victims' families seated. On the right-hand side, though, in the booth that you can actually see into on this photo, but usually it's closed, that's the place for the protected witness. And we have used all that, Evelyn, all the distortion of voice and the image in the broadcasting, as well as in broadcasting within the courtroom was used in these proceedings. But not all the witnesses and not all the victims are getting the protected status. Next slide, please. This is the same courtroom, just a different view. So this is the view from the judge's bench. So you can actually see how deep this courtroom is, and that more than 1,000 people can actually be seated in it. Next slide, please. This is a little bit different environment, but as we heard at the very beginning of our conference today, similar rooms have been created in Ukrainian courts. These are the rooms from Georgian courts. Similar ones have been established in Uzbekistan courts. This is actually a family room. It's not only for children, but these are for families. This is where families actually spend time either before being heard or while waiting for other members to provide their testimony before the court. Why this is called the family room? But it has been discussed that actually a family member, unless the family member is a perpetrator or an accused, is the best support in the courtroom or in the courthouse. So this is where basically the family members spend time. And you can also see that there is a direct connection to the courtroom. So this is also the place from which sensitive witnesses or underage witnesses can provide their testimony in Georgian and also in Uzbekistan courts. Next slide, please. This is a little bit different environment, and this is people-centered justice tendency on how to arrange the courts for all the users to feel welcomed. On your left-hand side is the actually a family courtroom. So this is a courtroom when you see where everyone's equal. The judge is not sitting in the bench, and the judge is not higher above everyone else. And this room is also used for mediation. But this is actually where family disputes are being resolved, and where everyone is basically treated in a friendly, respectful, dignified manner, regardless of the cause or the source of the dispute. On your right-hand side is the information space, so to say, in one of the Tbilisi courts in Georgia as well. And this is, the place where people wait to be called into the courtroom, to a specific courtroom. So this is how actually the reception or the main entrance of the court can be arranged to be more friendly for all the users, not only victims and witnesses. Next slide, please. France is the first EU member state that has introduced dogs in courtrooms to soothe anxious victims of crime. And on these services, as well as other services, I would actually strongly recommend you to look at the resources of the Victims Support Europe. It's a Brussels-based NGO, but that has been working effectively with a lot of European institutions. And they have actually pursued for the use of dogs, and the dogs have been effectively introduced in France as of 2021. I haven't heard of other European countries, but maybe other countries around the world have done a similar thing. So dogs that actually, on this particular photo, they help relax children that is supposed to provide the testimony, but dogs can be useful for all types of victims and witnesses. And I think this really completes this presentation. I don't think that there are any more slides to show, but what I wanted to stress, and I cannot stress enough, when it comes to creating a space where victims or witnesses could feel safe, you have to first really think about the legal framework, as Evelyn stressed. So the premises are also something that should be envisaged by the legislation, in which you regulate the victims and witnesses protection. Also, people who will occupy the space, the type of furniture that you will place there, etc., etc. And if you think of your state budget, or if you think of the donor assistance, it is all pretty expensive. Ultimately, I mean, like the cheapest measures that are really not the cheapest, but the ones that we had at hand when creating the unit for supporting victims and witnesses of war crimes were people with social skills. We did not have at hand psychologists or security officers or people trained actually to deal with the area, but we had a social worker, we had a juvenile justice specialist, and we actually engaged their knowledge and their skills to help us create the unit. So that's actually something that you have to think of first, apart from the legal framework, when you create this unit. We started actually from the War Crimes Court in Serbia, but we continued establishing these units around the country, and now all higher courts, and there are 25 of them, have the services for victims and witnesses, and this has been regulated by the law. The services of these units are equally used by prosecutors' offices. This is also very important, as speakers before me stressed. No one wants the secondary victimization of the victim. I mean, that's a torture. If someone had to go through the police investigation and then prosecutor's investigation, and sometimes there is an investigative judge in between, or investigator before the prosecutor, and then again to a judge, and in the courtroom, in front of larger audience. That's like, that person has been victimized several times in a row, and no one, I mean, that really, not only that ruins that person's dignity in life, but it also ruins the case. So you have to think of the purpose, why you're actually providing certain, special circumstances for certain groups. I could go on and on speaking about, peculiarities, but I am just a phone call away. I will be with you for a full hour and ready to answer your questions, practical or theoretical one. Thank you very much once again.
Thank you so much, Ms. Prostrom, for sharing your great experience and putting such a vivid emphasis on the importance of infrastructure developments and crucial pending assignments to improve court premises, prevent re-victimization, and treat all the users, besides victims, as you said, better. And this way, make people feel better. Please, Ms. Yevhenila Bondarenko, you'll take the lead. Thank you.
Дякую, пане Пальма. Ну що ж, шановні учасники.
Thank you, Dr. Palma. Dear participants, we will now proceed with the next team of speakers. Before we go down to the next section of our today's event, I would want to underline the importance of conferences like ours, since it allows for exchanging experience and best practices from all over the world. I could see the eyes of Ukrainian experts shining with interest when the previous speaker mentioned dogs in courts, because this is a sort of novelty. It would be a sort of novelty for Ukrainian courts, which are, by the way, quite experienced in introducing various solutions for the benefit of court users, not only vulnerable, but also regular ones. And I will now give floor to our Ukrainian speakers. The first one will be Oleksiy Nesterenko, Judge Speaker of Ingulets District Court. Madam Alina Kerakosyan, Chief of Staff of the same court, of Ingulets District Court of Dnipropetrovsk region, who will develop on practical solutions for vulnerable court users, which have been introduced in their court. By the way, the Ingulets District Court has become a winner of the model court nomination, which was awarded, the prize within which was awarded last year. So I will not continue more, and I give floor to Oleksiy Nesterenko. Thank you very much, colleagues. Thank you for having me here. Thank you for giving us the opportunity to become part of the Model Court Initiative, which facilitated and promoted the implementation of various modern and user-friendly solutions in our court. We have received much positive feedback from our court users, and I will now speak. Give a floor to my colleague Alina, Chief of Staff of Ingulets District Court. Thank you very much, Oleksiy. Dear colleagues, thank you. Welcome. We will now share the experience of our court together with my colleague Oleksiy. So I would want to start with mentioning that creating comfortable environment for court user is of crucial importance for the maintenance of confidence in the judiciary. I will now develop on a model solution which was introduced in our court, which we call children's room or children's corner. So this space has been equipped in order to provide a safe environment to children coming to the court, no matter what the status of a child is, whether he or she is a witness or a victim, or maybe just a child. The parents cannot live at home alone. To the best of my knowledge, more than 20 courts across Ukraine have been equipped in various courts. So having these child-friendly spaces allows reducing victimization, re-victimization of children, and preserving their mental health. Now, Alexei will develop on accessibility model solution. Yeah, thank you. Indeed, accessibility of public spaces for people with low mobility is of crucial importance because the right to have access to public spaces should be considered as an inalienable right of each person, including people with a low mobility. Unfortunately, before recently, very few public spaces were properly equipped for the needs of people with low mobility, including courts. As of today, some 95 courts all over Ukraine have installed ramps and provided and implemented other solutions to provide greater access to court premises to people with low mobility. Unfortunately, some court premises do not allow for ramps to be installed, or who even least allow the elevators to be installed for people with low mobility. So the solution here could be having a call button for so that the respective category of court users could call for help of court employees if needed. For example, in our court, we have such a call button installed. The call button is also equipped with a video camera, so whenever the call button is enabled, there is a court employee who would go out and help the person in. Another model solution which has been implemented in our court is consists in the installment of signage with braille font, both inside and outside the court building. Some 155 courts across the country have installed those signage with braille font. It includes signage for navigation in court premises and also various information boards. Besides, people from the court staff members are trained to deal with people with visual and hearing impairments. Another model solution consists in the in providing greater accessibility of court rooms for people with reduced mobility. So again, we have some obstacles, objective obstacles, because of some peculiarities of construction of court buildings, especially if courts are located in the premises which initially had not been intended to be courts. But here, what can help is empathy and a real willingness to help and to respond to the needs of people with reduced mobility. I can give some examples of ad hoc solutions for people with reduced mobility. So there is a court in Ukraine where there are 3 hygiene rooms for people with disabilities. Another solution includes a turnstile that can be lowered so that a person in a wheelchair could get in or out. And the third model solution consists in the use of respective equipment in a courtroom to fit the needs of people with disabilities, such as voice amplifiers, such as information boards with great font, and so on. So another model solution we would want to present here consists in the conduct of anonymous surveys and among court users, both in hard copies and using Google Forms. These questionnaires are further processed and the problems identified are being addressed. I would want to add here that we have the questionnaires available on the information boards, so anybody who is willing may profit from filling in such a questionnaire. And I have to say that having the questionnaires is a very good and practical solution, actually, because sometimes people would want to share their experience, both positive or negative, but they feel shy to do so, or maybe they don't have enough time to do it right here and right now. So to give them the possibility to pick up and have their opinion properly heard and taken into account, it is very practical to have both hard copies available on the information boards and links through QR codes, which people could use to fill in Google Forms later on. Another model solution will be presented by my colleague Alexei. Yes, thank you, Alina. So we've signed a multilateral memorandum of understanding with the Free Legal Aid Center, higher educational institutions, and NGOs. The memorandum of understanding covers predominantly the issues of involvement of volunteers to courts, so that they provide support to court users with the ultimate goal to consolidate efforts to provide greater protection of constitutional rights and freedoms of Ukrainian citizens and giving them greater access to justice and legal aid. Volunteers are mostly students of law schools. As you see, they are young people who are interested in acquiring experience in the field, and in the meantime, their role can hardly be overappreciated because they contribute to the decrease in workload of the court staff by providing consultations and explanations to unexperienced court users. And now we will go down to various types of cooperation. My colleague Natalia will better develop on this, so she will talk about various roundtables, conferences, webinars that we organize in cooperation with the NGOs and free legal aid centers and local units. So we truly believe that courts need to work closely with NGOs in order to be successful in delivery of user-friendly services. For example, in the framework of Zero Tolerance to Violence initiative, our court has announced social advertisement competition. We are free, equal, and strong. So the competition has been held in the framework of cooperation of UNFPA and NGO Innovative Social Solutions, and it has been supported by the USAID activity. It is no less important to mention the trilateral cooperation, which provides great access to justice for all categories of court users. So we are talking here about three main categories of partners, which are international donors, public institutions, and NGOs. And to sum it up, I cannot but agree with the previous, with my co-speaker. So people are crucial in the in creating user-friendly environment in courts, because only people who are motivated, only people who are truly engaged in what they are doing can provide not only some proper logistics, but also proper attitude towards victims, survivors, and vulnerable witnesses. in violent crimes, in war crimes. For example, if there is no possibility to equip space, a separate space for children or for vulnerable victims, a person from the court staff may offer help and suggest waiting in a different corridor, for example, or at a different floor, so that the victim does not have to face the perpetrator, for example, or for example, the court hearings involving minors can be organized or scheduled for a particular day. Thank you for your attention. Olina, Alexei, thank you very much for sharing your experience, for sharing best practices of your court. Indeed, people are of key importance. People are of greatest importance, and their engagement and their willingness to make a difference is something that does not require any additional funding or financial support. Everybody knows that people coming to courts are usually vulnerable anyway, because they feel anxiety, because they are find themselves in sort of turbulent life circumstances. So they need just some friendly attitude, some friendly support. This is the most important. Dear participants, let me remind you about the possibility to ask questions via chat. And let us continue with the agenda. And I will now give floor to Natalia Korol, who is head of the All-Ukrainian Association of court administrations in Ukraine, and her colleague Anna Mostecka.
Волонтерів у судах. Проект Право-Justice запроваджував 3
Private
навчальні
Justice Project implemented 3 training courses for vulnerable victims and witnesses, and Natalia Korol was the first to introduce the service in Ukraine. This court volunteers, and she already was a trainer at the second TOT, and Anna Mostecka is her student, but she very actively has taken up those practices, and it was so successful at her court that for best services she won the award at her court. But you know, what's very important here for the community of court administrators and altogether, it's healthy competition, because such exchange of experience makes it possible for the system to be efficient, open, and most importantly, create an atmosphere where a court is indeed open, and that makes it possible to make access to justice easier for vulnerable persons. Not to take up a lot of your time, Natalia, the floor is yours, and you will also share a little bit interagency cooperation that you are very actively implementing for vulnerable court services. Hello, everyone. It's a pleasure to be here today and to be sharing the experience of not only Vinnytsia appeal court, but of the courts that are united by this idea of improving access to justice for vulnerable court users. I want to reflect a little bit to those warm words, both as the speaker and the head of the All-Ukrainian Association of Court Employees. I very much share the words by Steve Jobs that there are no supermen. Everything decisive is born as part of a team, and introducing volunteering services in courts, first in the Vinnytsia Court of Appeal, then in 15, if I get it right, courts of Ukraine. That's teamwork. That's teamwork of very much, very experienced professionals who want to have changes implemented and they change the world around them. I want to start by saying that volunteering service is a very important element of improving access to justice, especially for vulnerable court users. And every time I emphasize that creating such a service, as far as the example of a court where I work is concerned, started not from memorandum and not from the rules, but it was all so much later. First, what we had, it was understanding of how much we need the service and how important this element is in terms of access to justice. So today, it's a big pleasure that all the participants understand the notion of victimization, of trying not to have a secondary victimization, and the EU Directive of 2012 is so much heard of among volunteers. And here I want to say that it's not just access to vulnerable witnesses and victims, but it's about the context of war times in Ukraine. The volunteering service started indeed for me with the certificate of the training course. It was a program suggested by EU Justice project, and indeed after this training I understood that we can implement what's important for people, what can simplify access to justice, and words of our previous speaker was it was that of course maybe it's the cheapest, but indeed the most important resource is people, and introducing volunteering services didn't require investments. It didn't require investments at all, but it was the internal desire of help, especially for those who came to the court for the first time. We can now see the map of courts where there are such volunteering services, 15 pilot courts from all over Ukraine, 15 courts that have different instances, jurisdictions. Moreover, they have different forms and shapes of how volunteering service exists, starting from integrated reception, finalizing with a very much full-scale interinstitutional interaction that will be better covered by Anna Mostetska. More than 300 volunteers. It's not just a number, it's specific people who had their names and young creative thinking and the main desire to help. Going a little bit ahead, I'll say that more than 172 are volunteers from Vinnytsia Appeal Court, and it's a pleasure for me to say here when we have more than 200 people present here with us. Next one, about rules. We always need the rules. Rules help us better arrange our work, especially when people are concerned, especially when vulnerable witnesses are concerned.
Тому що насправді теми
We need some rules and procedures because the sensitive topics necessitate respective attitude for vulnerable court users. At the same time, the special treatment must not traumatize them. It all started with the first rules that were set out in a memorandum. It was a unique memorandum. Why unique? Because we had 4 parties: Vinnytsia Court of Appeal, Vinnytsia Regional Free Legal Aid Center, Vinnytsia Trade and Economics Institution, the Department of Law, where we have such a team of volunteers. At the same time, we had the Agreement on Cooperation and the volunteering rules. Why volunteering rules? Because students needed to understand to what extent they can provide assistance and how they can do it. Of course, the criteria was the desire to help, empathy, being able to communicate, and at the same time understanding of the scope that is admissible. For example, it was inadmissible to provide legal aid. Students were instructed during their training that they cannot provide any legal advice. They can show around the court, they can serve as a navigator, they can accompany, they can refer either within the court, for example, to send them to respective structural unit, or outside court within interinstitutional cooperation. That's why getting to know the rules of volunteering is a must-have as far as such service is concerned. The 2-week training to become a court volunteer, it was enough. We had a probation of such approach. It's viable. First week is theory. It was about court, about its competencies, about what judges are doing, where courtrooms are, what are for criminal cases, what are the peculiarities, how we need to behave in court proceedings, what support they can provide to court visitors, how they can accompany them to courtrooms. All this they could hear during the first week of their training. Second week of their training was always practical, that is, volunteers together with court staff member directly at the entrance of the court could hear the participants and the ask. Also, it was necessary to be not afraid to communicate, and they practiced, they worked on their skills of how to properly provide assistance, how to provide proper guidance and help. All documents, all agendas, all curricula we very much happily shared with Pravo-Justice project. All of it was unified, and there were recommendations on introducing volunteering services in court drafted. It's a good handbook that's available for anyone whoever wants to introduce this. Such materials are available and they can be used. As far as importance of volunteering as court is concerned, all the 15 pilot courts can provide their feedback as to how much access to court was improved, how the court became more friendly and transparent and understanding. But the importance of such volunteering services shows the strategy in the strategy of for the judiciary and constitutional justice of Ukraine for 21-23 that shows that such association of the development of the justice sector, that in the very presidential decree we can see that it's necessary to create volunteering services in courts to make justice accessible. I want to say here that based on this decree in the Venice Court of Appeal, we also decided to approve the strategy of volunteering services because there were a lot of directions, and we decided to have a strategic overview of development trends by 2023. Right now, we are reviewing the strategy of our goals and our purposes, what we have achieved and what we haven't yet achieved. What we haven't yet achieved, you'll now see on slide number 3. Yes, here we see. So a biannual project, 2-year project, we have 172 volunteers. We have this bullpen of volunteers for Venice Court of Appeal. It means that after the full-scale invasion happened, 13 court staff members fled Ukraine. And sometime we felt that we had lack of people who were working, and we had a chance to engage ex-volunteers, and now our 2 court staff members, they were appointed to judicial positions, and the volunteers who volunteer today in court, their dream of working in court by providing volunteering services make it possible. It shows that it's possible, actually. Volunteers help us cooperate with organizations and institutions interested in improving access to justice, interested in providing better rights, a better level of rights for the victims and witnesses, especially in war crime cases and domestic violence cases, both within the criminal code and the administrative proceedings code. We widely cooperate with the Bureau of Institutional Development, and thanks to such wide dissemination of information about our work of volunteers in our court and interest in such rule of law by empowering justice in such court. Our court is represented in the working group on Barnehus system in Vinnytsia, and our court also cooperates with the territorial unit of Vinnytsia and the working group on improving access and on ensuring the rights of victims in domestic violence cases. And here volunteers also help us. Their help is very much tangible. First and foremost, it's law awareness activities where we engage them. They can also provide online help. What does it mean? It means that when there weren't full-scale court hearings, we provided court users by support via phone, via telecommunication, and volunteers were also of help to us, and also service for domestic violence victims. It's a very fresh, if we can say so, idea that was planned in the volunteering strategy development in the Vinnytsia court. We wanted to establish that service. We didn't quite know for sure how we can implement it, and at the level of our court, and such wonderful platform as Good Practices platform, it's possible to exchange experience, because when you share your experience at the same time, you get questions, you get feedback. So it's inspiring, and it helps think creatively and implement the ideas. And it will be also covering the members of the court staff of Vinnytsia Court of Appeal, and our court volunteers will be contributing to that service. And we decided that we will be looking into domestic violence cases. When we looked into the number of cases that are end up in appeal, we don't have that many cases of appeals in domestic violence cases, and shows that there is low level of support, that is persons who suffered because of war crime, because of domestic violence, didn't get due support. Maybe they were subjected to secondary victimization. That's why we are going to meet people. It means that such people, it means that we provide them exhaustive information about all the services, about our community. Of course, it's psychological support. It's persons understanding that they can get maximum comfort and security, and being together with such person in courtroom. That is the support that is concerned, even without having to spend some resources. More on institutional cooperation. You will hear from Anna Mostetska, my colleague, who was so much interested in this idea, and who was awarded as the best volunteering service, and that's very much awarded. I thank you all so much, and I will be happy to answer your questions. Thank you, Natalia, for your word and for your kind remarks. I welcome everyone. Dear colleagues, for me, it's a big honor to tell you about volunteering model that we introduced in Ternopil court. Our service started working in 2021, and it was a trilateral partnership between the court, the training the educational institutions, and the Free Legal Center of Ternopil that, while implementing the project, took on the coordinating role. We have signed 2 memoranda on cooperation with higher education institutions that train lawyers. We have selected most motivated students, and we started training them. We had 3 offline meetings before the training. Also, we had people from the court staff, from the court security service, from the free legal aid system, and we also invited a practical psychologist.
У записі, і ми використовуємо їх для подальшого навчання наступних груп волонтерів.
The recording of the training is available, and we use it to train new waves of volunteers. We also asked the candidate volunteers to provide certificates which would confirm having completed 2 trainings, free legal aid volunteers training and the training for volunteers working with vulnerable categories of court users. So having these minimum requirements to candidate volunteers allowed us to engage people with minimum knowledge and skills in the area. Our volunteers work in close cooperation with the court apparatus and court security service. It is important because according to the data we dispose of, some 300 to 350 people attend the court building every day. The volunteers have been engaged in accompanying court users and helping them to navigate in the court building, taking care of children, but they in the majority of cases the volunteers would provide psychological support to court users. We noticed that this is the most required assistance, type of assistance from volunteers, because usually people coming to the court are nervous, not to say anxious, so they may need help when in court premises and when doing various things, even the ones which may seem very simple at the first sight, such as filling in certain blank forms or asking information about a court hearing. Another thing to be mentioned is that we have streamlined institutional cooperation between our court and the Free Legal Aid Center and local units. So we would train volunteers to reiterate court users to free legal aid centers if needed. So according to the existing regulation, court staff as well as court volunteers are forbidden from giving legal advice to court users. However, it doesn't impede them doesn't impede the court volunteers to refer people to free legal aid system. So the model of volunteering that we have established in our court was presented by myself at various events. And at one of the events, it was so highly appreciated that we have become part of the redirection system for victims and survivors, survivors of domestic violence. So what does it mean? So it means that there is a system of support for survivors of domestic violence, and there are NGOs which give advice to such categories of victims, and the respective NGOs distribute leaflets where they list all information about support available to court victims, and we are among the contact authorities, contact bodies. So alongside our volunteering team, there are contacts of various social services, various organizations providing medical services, and so on. It is important to mention that some aid may be provided online, which is especially practical in the circumstances of pandemics or in the circumstances of war. Another thing I cannot but mention with great pride is that two of our volunteers have been awarded with a special decoration on the occasion of the International Volunteers Day for their contribution in the development of volunteering in Ukraine, and for their contribution to the rebuild and strengthening of public trust in the judiciary. Speaking of what we currently have in the pipeline, I am now actually training a new wave of volunteers consisting not of students of legal departments, but of students of social and psychological departments. We build on the previous experience while also polishing the knowledge and skills that students already possess due to their professional training in the university. Thank you. Natalia, Anna, thank you very much for having presented such an experience, such a mind-blowing experience, I would say. This is all due to your motivation and energy, because you demonstrate perfectly well how one can achieve great results without additional funding or involvement of additional resources. I can see no questions, so I am very pleased to give floor back to my co-moderator, Dr. Palma, for the closing remarks.
Thank you so much, Ms. Bondarenko. We could start, if you please, with the questions and answers. Ms. Bondarenko will pose to each speaker the questions written in Ukrainian, and I'll do it with those in English, in case we have.
Поки що в чаті питань немає, можливо, у когось.
We cannot see any questions in the chat section so far, but there might be participants who are willing to ask questions right away or to share their ideas or opinion in respect of what we have discussed today. So the only messages we have in the chat sections are the messages of appreciation and gratitude to all the speakers. And I think this is quite logical because we've heard a lot of great things today.
Absolutely. We can open the virtual floor then to dialogue if any of the participants would like to pose, orally, what they intend to say.
Я поки що озвучу питання в чаті від учасників.
It seems that we have one question in the chat section, so I will read it out now. So the question consists in the following: in order to become a volunteer, does a candidate need to have a diploma, a bachelor degree at least in law or in social sciences, or it is enough to be a student? I will put it in the following manner. So when we started, when we initiated that discussion about establishing the volunteer service in the court, it gave rise to some vivid conversations inside the court, because it was the matter of access to court premises and given basically access to premises in the court building, which are usually closed to the visitors. However, after having all those discussions, we decided that we can engage students, first years, including students of first years of study. So there is no need to have any degree in law or any particular knowledge, legal knowledge. So we just wanted to have motivated people on board, especially considering that there is a person who guide the volunteers and basically somehow govern their activities. However, at some point in time, we realized that it would be nice to have more people with the bachelor degree because they could be invited to fill in the positions in the court apparatus due to the lack of staff, especially after the war outbroke. but in general, we have students as volunteers. Thank you, Natalia. And I can see another question in the chat section. Who remunerates the activities of court volunteers? So I will try to answer the question right away. So everything started back in 2020 when the EU Project Pravo-Justice presented the court volunteering model from Lithuania. And the answer regarding the remuneration is very simple. There is no remuneration. The volunteering is based on mutual interest of all the participants involved. So the students of law departments, of law schools have the opportunity to get some experience, to see how the judicial system works from inside, to have a very practical insights, while the courts benefit from support provided by volunteers free of charge to the court users who may need such support. So this is mutually beneficial activity where there is no remuneration, where there is no money involved, but just mutual interest. And probably Anna could add something here. Yes, Evgenia, thank you very much. Indeed, not a single penny was spent to volunteers for building up the volunteers service in our court. So we, at the very beginning, I have to admit it, I needed to convince the president of court and the chief of court apparatus before they gave their permission and before they agreed to initiate the build-up of volunteering of the volunteering service in our court. But I managed to do that, and then all the way forward, I felt supported by Evgenia Bondarenko, by Natalia Koral, and I have to say that everything was built on pure enthusiasm of myself and of other people involved. And you know what? The volunteers, so those who became our first volunteers, but it's also applicable to the ones we have on board now. So these people are willing to engage as volunteers, sometimes at the detriment to their studies. So at sometimes I need to remind them that they are students in the first place, and only after that they are volunteers. So studies should come first. I would want to add something here. So the question, how much is among the most popular ones, but it was not in the corner of discussion here. So we have trained several cohorts of volunteers of 10 to 15 people. And even though those people came as volunteers, we still needed to motivate them. And for example, one of the solutions to motivate candidates was to invite them to a morning coffee with the president of court. So trainees would be invited for a cup of coffee or tea with the president of court, and that was a very great deal of motivation because some volunteers would even ask me, so it is not that simple to get to the court president's office, isn't it? And they had that opportunity, and they would ask questions about his professional career, etc. And besides, there was another initiative which consisted in a volunteer be invited to attend the court building early in the morning when the court is getting prepared for a new working day. So that was an opportunity for a person to see how everything works and from inside. And another way to motivate volunteers is to engage volunteers in the discussion about what can be improved in the court, and sometimes we even need to slow down the avalanche of ideas we receive from our volunteers. So they are currently, due to their proactiveness, the volunteers are currently involved in mentorship of newcomers, and they also get engaged in some administrative support of courts in terms of managing interns coming to the court.
Ми створили чат в телеграм-каналі і багато онлайн навчань.
We created a Telegram chat. We had many trainings with volunteers who communicated not only with judges, because we understand that judge is a person that is quite busy and the president of the court cannot spend that many time with students, but the free legal aid was very helpful. They answered many practical questions of our volunteers, and also when it was possible, we took part in open hearings that can be attended by everyone, but given that for judges come to court, they could also take part in court hearings as listeners, as attendants. That's also another motivation for students, because it can be useful for people who have no idea how the court hearing goes. Also, there was a question in the chat about training of court volunteers in the National School of Judges of Ukraine. The trainings for volunteers take place on distance learning platform on Free Legal Center, and there students take courses, they answer questions, test questions, they get the certificates on their status as a volunteer for vulnerable court users. For example, now we're court volunteers together with the free legal aid system. We also had the memoranda as to who signs it. On the part of the court, it can be the president of the court, or if there is an order of the president of the court, it can be a judge speaker. In our case, Mr. Alexei was signing it. Then it's free legal aid center representatives, then representative or the head of the state of the educational establishments from where volunteers come from, and where possible, the fourth party can be territorial unit of the state judicial administration of Ukraine, and that it's impossible to do without volunteers, and the court is amazed. Yes, indeed, volunteers is good. It's practice for the students. We also had the memoranda on this practice during the studying for students. First and foremost, it's content and contact and communication with people, either children or some limitations, but we have the place where our volunteers can interact with children while their parents are in the court hearing. So we also provide such kind of opportunity. Thank you, Alina. Also, we see comment in the chat. Do students spend the whole day in the court? What about studying? It depends. If judges and courts, they adapt the system as they see suitable, and volunteers can come, for example, the second half of the day when they don't have the studying, then it doesn't complete the hearing, or when they have holidays, they can volunteer a full day. These are all technical opportunities that it's possible for each organization, and that's an answer to a comment as to whether have centralized memorandums. Centralized things don't work here because we need the interest and mutual enthusiasm, both on the part of the court and on the part of free legal aid that we implemented together. That, and also there should be interest on the part of the university. When some of these chains are not there, we feel it. There are 3 or 4 party memoranda, but given the number of questions, I guess if there is such a request, we need to have a separate event so that now we can go to other parts of our conference. Thank you all, dear participants, for your questions.
Thank you so much for the outstanding presentations that pictured vividly such admirable efforts and achievements to provide an effective support to vulnerable groups of court users and victims of war crimes, and to continually improve justice services at present times and far beyond. Interdependence, awareness, cooperation, volunteer work, and continuous training are key to make it happen now and then for the best of the people. Thank you to Ms. Bondarenko for such a wonderful moderation. Thank you all for being such a great, committed, and enthusiastic audience. Soon we'll post on the IACA website the link to access to the conference recordings. We'll keep you posted about the date and time of our next online conference of the program. Please stay tuned. Looking forward to meeting with you soon again. Thank you all so much. Have a great day.
Дякуємо, до побачення.
Thank you so much. Goodbye.